ready, Steve?
Now there.
So call to order the Wednesday meeting, October 24th, 1918, for the Mount Pleasant Zoning Board of Appeals is now called to order. Mr. Kench, please do the roll call.
Sure. Asman? White?
Here.
Friedrich?
Here.
Orlick?
Here.
Raisman?
Here.
And Berkshire.
Here.
We have a quorum, Mr. Chairman.
Thank you. Excuse me. The next item on the agenda is the approval of the agenda. Does anyone have any changes they would like to make to the agenda?
Move to approve the agenda.
Second.
All in favor?
Aye.
Aye.
Any opposed? Next on the agenda is the approval of minutes from September 26, 2018 meeting. Are there any changes or revisions?
Move to approve the minutes.
Second.
All in favor?
Aye.
Aye.
Any opposed? On the agenda is communications. Mr. Kench, do we have any communications to report?
I don't have anything to report at this time.
Okay. This is a time for a public comment period. During this part of the hearing, the floor is open to anyone who wishes to come forward and speak. Typically, this is reserved for time for comments that are not related to any of the cases that are on the agenda for tonight. Anybody wish to come forward and comment? Seeing that there's no public comment, that part of the hearing is closed. So now we go to the public hearings for tonight. There's a potential for two cases to be presented to the board this evening and involving an appeal of the building official's decision under case number ZBA 03-2018 at 205 South Main Street, filed by the Kerr Trust and Estate Elder Law Firm, PLLC, and potentially ZBA 04-2018, also at 205 South Main Street, filed by the Kerr Trust and Estate Elder Law Firm, PLLC. In accordance with our established bylaws and board procedures, the applicant will be called forward to state their case. Following the applicant's presentation, the public hearing will then be opened. Anyone who wishes to address the board will come forward, sign in, and state their name and address, which will be made a part of the permanent record. Each person will be allowed to speak for 5 minutes. In addition, each person will be allowed to address the board only once unless they have new and pertinent information to share. The public hearing will then be closed. Any correspondence received regarding the case will be presented to the board. At this time, Mr. Wood, who's the attorney for the city, will provide us with background regarding this case.
Yes, both the appeal and the variance request involve the property at 205 South Main, where the applicant conducts his law practice. He owns that building. He currently has a brass sign facing Main Street.
And he now wants to add a ban sign. In his appeal seeking interpretation of the ordinance, he articulated 3 questions, 3 issues. One is what constitutes a roof structure for purposes of the sign placement, essentially asking that it be found to be part of the facade so that he could put the sign on the roof structure. The second issue relates to whether the sign can be attached to the columns. I don't believe that issue is still in dispute because by letter dated October 4 of 2018, the building official addressed that with the applicant. The third question essentially involves an interpretation of ordinance section 154.414A1 little e, and essentially asks that that subsection be interpreted so as to allow new signs to be installed that would be consistent with existing non-conforming signs. In the event that the interpretation appeal is not granted in favor of the applicant, he's also filed a variance request, the criteria for which are set forth in section 154.608, and the ZBA should make a record of findings as to each of these, including the basis for its decision.
Okay. Thank you. Any questions for Mr. Wood at this time? Hearing none. So, will a representative for the appellant wishes to speak, please come forward. State your name and address as well.
I'm David Kerr, 205 South Main, and I only rise to introduce Matt Zimmerman, who will be speaking on behalf of our firm. Abraham Lincoln said that an attorney who has himself as a client has a fool for a client. And so I try not to be foolish, and would like to introduce Matt Zimmerman, who does a lot of zoning work, assists cities in that, and is well-versed in this area. So, Matt Zimmerman.
You just stay right there in case you need to answer questions from the Planning Commission. Good evening. As David mentioned, Matt Zimmerman is my name. I'm from the Varnum Law Firm in Grand Rapids, and happy to be in front of you this evening. Now, I know as a municipal attorney that you're required to handle both of these matters pursuant to the Zoning Enabling Act, the appeal, and then the variance, as Mr. Wood indicated, but we're the only ones on the agenda, and I'm happy to discuss them any way you want. Obviously, we've submitted both of them for the same goal, and that is the sign, which I saw on the screen earlier, and I know you have because it's part of the application package. So that's the building, and that's the facade, but I believe that Mr. Kerr has provided as part of his original application a photoshopped image of what the property would look like with the band sign across the front of that structure. And yes, I see you've got it here, so that's great. So in reality, the zoning ordinance for the city maybe doesn't expressly deal with this type of structure. The building official, in denying the application for the band sign, said in responding to the application for sign permit dated September 17, 2018, I am not able to approve a band sign on the roof structure attached to the facade of your business. We respectfully debate that that structure is not a roof. I don't have any legal citations to provide to you, but I think common sense would indicate that a roof covers part of a structure. I know you can have a roof on a porch. That's still part of the structure. I think the porch is still part of a house. The structure that I'm referring to is the red cedar-shaked wooden extrusion coming out from the facade, and it covers public sidewalk. So one of the appeals that Mr. Kerr specifically referenced was that this is not a roof. And I wouldn't, again, argue too strenuously that whatever it is, maybe it's just not covered by your ordinance. And we all know that a zoning ordinance can't cover every single permutation or type of structure that can be built out there. It would end up being, you know, as big as a New York City phone book, and then it still probably would miss something or other. And that's why there's a zoning board of appeals, and that's why you have the variance process. And that's why we filed an application for a variance. So when I first spoke with David and looked at your zoning ordinance and tried to figure out what the sign that he wanted was, I thought a little differently than him that, well, this was an awning, and that really this is an awning sign. But I could also see where it's a band sign because that structure that has the cedar shakes on it isn't defined anywhere else in the ordinance, and the definition of facade within your ordinance doesn't limit it to just the flat surface. And when I was glancing through your ordinance, right on the page, I think it's page 60, the first page of the C5 district, which I believe we all agree is the district in question, there is a rendering and a couple of photographs of buildings. In one of them, the bottom right-hand corner, page 40, might be page 42 of one version of the ordinance, might be page 60, shows some bay windows. And bay windows stick out from the vertical face of the building, the facade, if you will, and overhang, in this particular case, overhang the sidewalk. And I'm pretty sure that most of you would consider that bay window to be part of the facade. And if there was a way to wrap a band sign around that, I think you would allow it as a band sign. And so in that respect, I believe that Mr. Kerr makes a pretty good argument that you could consider this a band sign. And that's why we made the appeal. I think you could also, as I indicated earlier, call it an awning. Now, I understand the definition of awning in the ordinance doesn't allow the sides to be solid or filled in. So that's a problem that we'll address in the variance request. I think you could also call this potentially a porch because it's a roof that doesn't go all the way up to the top of the structure, and it does cover some things, but it doesn't cover any part of the structure. It doesn't cover private property. It's covering part of the sidewalk, although maybe it's only out far enough that, does your property line go to the edge? No, it's somewhat over the sidewalk, right? Okay. So, maybe that's not, I can see where it might be considered a porch, in which case I think the sign would be allowed at that juncture. It might also be considered a marquee, and even though it's not illuminated, but marquees are allowed, and so there's many different ways that I think you could consider this. All of them would be necessitated by and premised upon this structure not being considered a roof. So that's the nature of our appeal. The standards in your ordinance are found in section 154.607C, and the appeal from the building official's decision, if you find that it's not authorized by law or not supported by competent material and substantial evidence, then you're allowed to reverse that decision. And I've made the argument that I think there's competent material and substantial evidence that this isn't a roof. And in terms of the not authorized by law, I'm not threatening lawsuits by any means, nor is Mr. Kerr. I'm simply stating that under Michigan law, and Mr. Wood is your attorney, and you can ask him if I'm accurate in this, but under Michigan law, all ordinances, zoning ordinances included, have to have a rational basis. They have to have statutory authority, and then the actual specific regulations must have a rational basis to meet the purpose that the state statute authorizes you to make in adopting the ordinance in the first place. I can cite case law. It's called substantive due process, and you know, I can give you the Scott's Ventures versus Hayes Township case, 212 Mishap 530. That's a 1995 Court of Appeals case, or Rogers versus City of Allen Park, 186 Mishap 33, a 1990 case. And you know, they cite the Highland Park case, kind of the seminal case. And what they say is that, and I'm reading from the first of the cases I mentioned, the Scott's Venture case, when they talk about challenging a zoning ordinance on substantive due process grounds, that the moving party has to show that there's no reasonable government interest being advanced by the zoning classification itself. And to not allow Mr. Kerr to have a sign that's functional, that can be seen by people other than pedestrians, I think doesn't pass that standard. Not only does he have people coming to his office that are looking for it, but he has a reasonable expectation as a business person to be able to show from, you might call it advertising, but from a perspective of identification, a sign that can be read from a reasonable distance, like a person driving by in a car or parking across the street in the public parking lot, or driving crossways to the north. And under your ordinance, yeah, go ahead.
Is this explanation dealing with the variance or with the decision by the zoning official?
Well, both, and that's why I said at the beginning that it does kind of cross over. The primary fault that we found in the building official's decision was calling it a roof.
Mr. Chairman, I think we should handle the appeal
Right.
clearly and definitively before we entertain conversation about the request for variance.
Yeah, I would entirely agree with that. I think we have to keep them entirely separate from a symmetrical standpoint.
Okay, that's fine. So then I'll address, I've already addressed one of the two standards. The other standard that I mentioned, the case law in connection with that as to whether there's the decision or the interpretation that the building official made of the ordinance, whether or not that is authorized by law. He must have implicitly, even though it's not spelled out in the letter, interpreted the facade. The definition of facade is not including this structure, and yet there are other extrusions from the vertical wall of the facade in many other places where I think you probably would consider that part of the facade. So there's, you know, no rational basis to include one and not the other. He must have also implicitly included or concluded that this wasn't an awning because of the side being solid, and the definition in your ordinance about dealing with awning says that you can't have any side panels. And I would tell you that, in my opinion, that is not, there's no rational basis for having that definition of awning if this, in fact, in most people's opinion, is an awning. You might argue that the requirement to have no side panels would allow light to get through, and yet your ordinance in the definition of awning allows it to be made of metal, painted metal. So I don't think that necessarily holds water. The other signs that might be allowed, the band sign as interpreted by the building official would have to go underneath the horizontal extrusion, this wooden structure, and it simply doesn't fit there. So what Mr. Kerr is left with is no other means to get his sign in a proper size to the motoring public. He could put up a large projecting sign under your ordinance, but frankly, that is so uncommon within the city and of would stick out in such a way that it just would not lend itself to the nature of Mr. Kerr's business. He works in trust and estates and in elder care, and he's not trying to show off any kind of flashy or ritzy or loud, large sort of presence with his name up there. He wants something that's a little more understated as he had applied for. So in all of those areas, the building official, must have determined that they don't apply, the marquee that it somehow doesn't apply, even though other marquee signs could be much bigger and much larger in terms of the face of the sign. And even a porch sign, there must have been some implicit determination that this wasn't a porch, and yet, you see porches on the fraternities down the road that have signs, again, that were bigger than what has been proposed. So in addition to the no rational basis, I think there's a potential equal protection claim here as well, that there are similarly situated businesses in the same district that have signs or are allowed to have signs, but simply because of the dimensions and the shape of the facade that Mr. Kerr has, he's being excluded from having that same right. So
We're getting back to a variance discussion now as opposed to...
I understand that. This is, again, the not authorized by law is the standard that we have to show to allow you to reverse the building official, and that's one reason why I believe that decision is not authorized by law. So we're asking that you reverse the building official's decision and indicate that the structure coming off from the facade is not a roof, and therefore it's like a bay window. It's part of the facade, and therefore a band sign would be allowed across the face, the vertical face of that facade. That's what we're asking in the appeal.
Thank you.
Sure.
Any questions from the board?
I have a question, Mr. Chairman, and it might be a question that's best answered by Mr. Kinch. Where exactly does the property line stop for this building?
I believe it's the face of the building, the stonework, the brickwork, correct?
Right, David?
You're talking about the lot. It stops at the sidewalk. But if you're talking about the property line, the overhang has been there for over 50 years.
Right. You have, what I'm looking for is the front property line. Our ordinance talks about,
The property line is right at the edge of the sidewalk.
right, face of the building,
So the face of the building.
face of the building.
Okay. I think that matters in
That's how we define facade.
a determination of whether this could be considered a porch, because the ground property does not belong to the appellant. So I wanted to make sure that was clear.
So I think I own the overhang.
Yeah, I don't think anybody's disputing that.
Just the structure, or are you talking about prescriptive easement or adverse possession? I mean, if,
Been there for 50 years.
right, before there was a statute prohibiting adverse possession against municipalities.
That's not,
That would be something they'd have to take up in circuit court.
right, that's not something that this body is going to address.
Understand.
Other questions from the board? I have one. So you mentioned a bay window sticking out, and there would be a roof on the bay window, correct?
Well, it's obviously not open air, but there's a top to the bay window.
Under our ordinance, each district refers to certain permitted encroachments, porches, bay windows. In this district, if you go back, you'll see that a bay window is a permitted encroachment. You can extend beyond the facade.
But your contention is that the awning, roof, whatever this is, we'll decide that tonight, is similar to a bay window sticking out.
Right, it's part of the facade. It's a decorative part of the facade, no different than the, you see above the windows, there are a stone, decorative stone in the middle of the arch over the window. That sticks out, same as at the top, the fascia, the cornice sticks out. It's all part of the facade, I believe. Under common understanding of that term, I don't believe your ordinance is specific enough to be able to definitively say one way or another.
I think it is, actually. The way we defined the facade, just for the record, it says an exterior wall of a building that is set along the frontage line. Frontage line is another term that's defined in our ordinance. Under band signs, which we're trying to determine tonight, it says a sign that is flat against the facade and placed directly above the main entrance. And so that was the position that we had taken in the letter that we had sent back to Mr. Kerr. The roof structure at one point was a permitted encroachment. It was allowed to be constructed, but it's constructed out beyond the property. No different than what we would do on a bay window or some of the other permitted encroachments that are outlined in our zoning ordinance in each district.
Is this structural encroachment basically a grandfathered nonconformity?
It is grandfathered.
So any new building wouldn't be allowed to have that kind of encroachment.
They could only have the type of permitted encroachments outlined in the zoning ordinance for each district, which could include a bay type window.
And for me, the important piece of that is it's a grandfathered nonconformity.
It is. Do you have further questions for the applicant?
I have another question, which maybe you can answer, or Mr. Wood, I'm not sure. So if a decision to reverse the building official's interpretation of the statute, would that affect future construction that might happen downtown, and that they could also have an encroachment that way?
Well, if you're making an interpretation that you could put that kind of a sign on those kind of structures, yes, because that's how you're interpreting the ordinance.
Other questions from anybody? Nope. Thank you.
Thank you.
At this point, we'll open it up for a public hearing on the appeal to the building official's decision. Anybody wishes to come forward, please do, and state your name and your address. Seeing that nobody came forward, we will close the public hearing on this appeal. Mr. Kench, is there any correspondence to share?
There's nothing to share with the board at this time.
Okay. At this point in time, the board can have discussion among ourselves about the appeal.
To me, there are a couple of issues here in terms of the request to overturn the building official's decision. Mr. Zimmerman raised a couple of points, one related to the analogy to a bay window as a decorative part of the facade. But to me, what we're looking at here from a structural standpoint in terms of where we're going to mount the sign is far more than a decorative part of the facade. It is, in fact, a very functional and broad-ranging addition to the building. That's one thing. Secondly, council raised the issue that about the appropriateness of the awning definition in the ordinance. That really isn't our province to deal with. That's the city commission, or maybe if you take one of council's arguments, maybe circuit court. But this board has to live with the definition that's in the ordinance in terms of the closed sides. So those are two key elements to me, I think, in terms of what we're looking at here, which is why I think the building official has appropriately defined what we're looking at.
Other comments from board members? Go ahead.
I agree with Commissioner Orlick in his commentary. I also think that this body, as well as general public policy throughout the state of Michigan, tries to reduce nonconformities. We heard an appeal last month that, you know, under our ordinance, when you have a nonconformity and you want to make a change, the goal of that is to make a reduction in the nonconformities of the structure. And so to that end, I'd like to make a motion. I'd like to move that this board uphold the decision made by the building inspector.
Support.
Any discussion on the motion? Hearing none. All in favor of the motion is, we need to restate the motion. Excuse me. Go ahead.
I move that this board uphold the decision made by the building inspector.
Okay.
Does that cover what needs to be said in the motion legally?
You're referring to the building official?
The building official, yes, the building official, Mr. Kinch.
Right. Okay. All right. In that case, all in favor of the motion?
Aye.
Aye.
Opposed? The ayes have it, so the motion passes. The building official's interpretation is upheld. I assume it.
Mr. Chairman, can we have for the record whether or not that was a unanimous decision?
I assume it was unanimous. I think we all said yes.
Okay, yeah,
Okay.
just for the record.
Yep.
And because this was an appeal, our decision will, it's a little different in the way that our decision is recorded. I think, don't we have to state that?
The basis is you affirm the decision of the building official. You've done that.
Right, yep. At this time, I assume that we're now going to the variance, which is ZBA 04-2018, 205 South Main Street, filed by Kerr Trust Law Firm. And at this point, do you present, or
I'm going to let
Mr. Wood
Mr. Wood,
present?
you give us just some
Okay.
background on the variance.
Background then.
The background is very similar, given that it's the same property, but you need to look at the criteria set forth in section 154.608 for a non-use variance. And I would note that the applicant has to demonstrate that all of those conditions exist that are set forth therein. You'll note that in section A, there is the general statement of the variance requirements. It actually overlaps if you read each one of the subsections of subsection B. So there is a bit of redundancy there, but in any event, all of the criteria under that subsection 154.608B would need to be met.
Okay. All of them. Okay.
That's expressly what the ordinance requires. It says that to obtain a non-use or dimensional variation, the applicant must show practical difficulty by demonstrating that all of the following conditions exist, and then it enumerates 1 through 6. And those are addressed in various fashion in the applicant's letter that was submitted and attached to the variance application.
Thank you. Okay. Any questions for Mr. Wood? If not, the appellant at this time, if they wish to, or
Get that section up here for us.
it's not an appellant at this point, it's the applicant for the variance, I'm sorry. This thing's all confused here.
I think we can see that, can't we?
Does the applicant wish to speak? And I'm sorry, you have to restate your name and
Yes,
address.
certainly, yeah. Matt Zimmerman, attorney representing the applicant, David Kerr and Kerr Law. So, as I indicated earlier during the application process, this really is the same goal for Mr. Kerr, and for various strategic or legal reasons, we had to go through that appeal to get to what we both understood all along to be the real, the best approach to deal with this situation, because once again, it's certainly possible that your ordinance simply wasn't written in order to cover this type of structure, and that's not to be critical in any way of the ordinance. As I said earlier, this ordinance, any ordinance, cannot be expected to cover every single permutation of building styles or types. So in light of that fact, this body has the legal authority to grant variances, and I think that there are 4 different variances that could be given to deal with the fact that the ordinance isn't specific enough to cover this type of structure. And in addition to the standards in section 154.608B, I wanted to just briefly cover what some might consider standards in section 154.608A, even though that is entitled variance authority. It does say that the Zoning Board of Appeals may grant variances upon finding based on reasonable evidence that the variance will not be detrimental to adjacent property or the surrounding neighborhood and will not impair the intent and purpose of this chapter. And the chapter, I believe, is referring to the entire zoning ordinance, chapter 154. So just very briefly, and this will be repeated because some of the standards in sub B are quite similar to that, or maybe even identical. Right next door to the property in question, the subject property, is another building. There were actually what are now 3 buildings, but they were built all at the same time. It was one building, and they had the telephone company and the gas company maybe, and the electric company had this structure across the front, covered all of them. Mr. Kerr only owns the north third of that building, and right next door there's a business, and next to that is a related business, and they will not be hurt if you allow a sign to go on the front of that structure that, for lack of a better word, I'll call an awning. In fact, they wouldn't even see it because they won't be able from their property to see the west frontage, the west elevation of that structure. North of the building, you have a road. There's a vacant parcel that had the first building, Central Michigan University, before it burned down. That's vacant now. So no adjacent properties would be impacted at all. And then the surrounding zone district, the C5 district, Mr. Kerr in his application for the ban sign, which was appealed that we heard a few minutes ago, included in his application an Exhibit C, which has, I believe, 63 photographs, and those are of the buildings within a block or two of his that are all in the C5. and they all have signs, and a lot of those are, I understand, are non-conforming signs. We're not looking to those signs as a way to say they have similar structures with signage on it, so we should be able to do that. I'm only raising that from the perspective of that those property owners are not going to be impacted if you were to allow, or if you were to grant a variance that allowed Mr. Kerr to put the sign on the valance, the awning, if you will, or whatever we want to call that structure. So they all enjoy signage, and they all are business people that I believe would not begrudge Mr. Kerr the same rights that they have, whether it's by nonconformity or otherwise, to be able to advertise their business. So that gets us into the subsection B of the ordinance and the 6 different standards that are listed there. And if you would give me the latitude of a few minutes for purposes of the record, I would like to go through every one of the standards and indicate why I believe that the request for variance meets those standards.
Yeah, that would be appreciated. I was going to ask you for that. Typically, we have it filled out on the form, and it wasn't, and it was very difficult to extract that from the cover letter.
Yes,
so I'd prefer you do the extraction rather than me attempt to do it.
I'd be
And I was going to
I'd
make
be
the
happy
same
to do
request, so.
that. Yes, so standard number 1 requires that there be exceptional or extraordinary circumstances that do not apply generally to other properties within the district. So again, we're looking at the C5 district. And I believe that there are such exceptional and extraordinary circumstances, even though there are perhaps as many as a dozen properties in that Exhibit C, photographs of businesses that have some sort of extrusion from the facade, some sort of structure coming out horizontally from the facade, overhanging the sidewalk. There's really only 2 of them that are close enough to what Mr. Kerr has to call them similar, they're wooden structures, they have side panels, they have an angle, a 45-degree angle from the facade, and they have cedar shakes. One is just a couple doors down, and one is around the corner. They're both in that exhibit. One's painted blue, and one is more the color that Mr. Kerr's structure is. And both of them have signs, and I have to believe that they're non-conforming signs, and so again, we're not pointing to that to show or to argue that we should be able to have signage too, but it does show that it's a pretty extraordinary situation. In fact, it's the only type of structure that doesn't have a sign in the district. So I think that's pretty extraordinary and exceptional. The second standard is that the variance is necessary for the preservation and enjoyment of a substantial property right possessed by other properties in the same district. And again, we're looking at the C5. And I apologize for having treaded into this standard during the appeal, but I do believe that the right that everyone else in the C5 possesses is the right to install a sign advertising the on-site business that is large enough to be seen by non-pedestrians. There are certain types of signs that the ordinance permits that can go on the facade, little identification signs, street number signs. Those typically can't be seen by the motoring public. And there are even some signs that are called blade signs that, given the configuration of the awning type structure, really wouldn't be visible well from, certainly from property, or from traffic coming east or west, or the cars that would be parking in the public lot. And I'm not even sure that you could fit a blade sign because the size of the awning structure is such that the blade sign would be too low people would, it'd be a safety hazard, people would bump into that. I don't think a blade sign is big enough really to be seen well by the motoring public in any event, but I believe that that's a property right that's enjoyed by everybody else in the district. Some of the people have been able to take advantage of that property right by non-conforming use. Others have structures that allow them to have that type of sign, even where they have some structures that extend over the sidewalk. And some simply don't have those types of structures. When the building was built, they didn't have those types of structures, and so they can have band signs and others that are seen by the motoring public. So I believe that that standard is met as well. The third standard is that the variance is not of such a recurring nature to make formulation of a general regulation reasonably practicable. And what that standard means is if you've got every other lot in the entire district has the same condition, then you really ought to just amend the zoning ordinance and deal with it that way instead of granting variance time and time again to everybody that wants to do the same thing. As I had shared with that first standard, I don't believe there's more than two similar structures than what Mr. Kerr has, and both of those structures already have a sign. So unless they want to expand the size of their sign, or if the building burns down, they don't need a zoning text change in order to allow signage and the right that I described a minute ago. They already have that right. And so what we're left with is a single parcel in this entire district. And so I doubt that the City Council would want to spend your time, or excuse me, the Planning Commission's time, and then its time dealing with the zoning ordinance that would only affect one parcel. The fourth standard is that the variance would not be of substantial detriment to adjacent property. Now, I covered that in the sub A part of section 154.608, and I would simply leave it at that because I think it's pretty clear that putting that signage across that structure at Mr. Kerr's property would not have any negative impact to anybody, and in particular the adjacent property owners. The fifth standard is that the variance would not materially impair the purpose of this chapter or the public interest. And I think that standard is met by looking at all the other types of signs that your ordinance allows and in this district. And once again, I ventured into this area during the appeal, and I apologize for that. But if this were considered an awning, a sign could go in the same location that Mr. Kerr wants to put a sign. If this structure was considered a marquee, then a sign could go on the front of that. If it was considered a porch, you could have a sign on that porch. And you can have a large projecting sign, which is much more intrusive than the sign that's proposed. And so the ordinance allows all of those types of signs. So having a sign that's of similar shape or size, actually probably smaller than most of those signs, I think makes it pretty clear that the purpose of the ordinance wouldn't be defeated. I think the ordinance simply missed a certain type of building front, and we're asking for a variance to allow a type of sign that is allowed on other properties that don't have that same architectural design. The last standard is that the need for the variance is not created by any action or of the applicant or previous owner, and that one I believe is met because this building is old enough that when it was built, the sign ordinance didn't exist. I'm not even sure the zoning ordinance existed, certainly in its current form, when this building was built. When this building was built, I'm not aware of anything that was problematic from the standpoint of this particular design. And if the early owners had been private enterprise business owners as opposed to regulated utilities that didn't really have to worry about winning customers, they probably would have had a sign on the valance of that awning structure, and we wouldn't be here today because Mr. Kerr would have replaced that sign with his own sign when he moved in, and it'd be a nonconformity, and we wouldn't be here. So I don't believe that the person that designed and built that building did anything that would lend itself to us needing a variance today. So as I indicated at the beginning here, I think there's 4 different ways that you could grant a variance from provisions of your zoning ordinance to allow this sign to go in. So the first way would be for the band sign. The band sign under your ordinance is limited to the facade, the first story facade, and I think by implication in our appeal you've indicated that this structure coming out from the facade going over the sidewalk is not part of the facade. So one way to allow this sign to exist would be to amend or to vary the requirement in the ordinance dealing with band signs and allow a band sign on the facade on the valance of a structure identical to what Mr. Kerr has, however we want to define that, whether it's an awning made out of wood with side panels or whether it's simply a horizontal extension from a facade that extends over the public sidewalk. But that's one way that you could do that. A second way would be to say it's an awning, which is what I indicated earlier that I thought this was, and grant a variance from the section of the ordinance dealing with awning signs that says there'd be 2 variances that would be needed there. One is that the awnings that are allowed to have signs aren't allowed to have sign panels, and second is that they're supposed to be made of opaque material or painted metal. And this particular awning structure is neither of those, and so you could grant variances from both of those conditions, and we could call this an awning sign. We could look at the marquee sign provision of the ordinance, and you could say if this doesn't meet any components of the marquee sign definitions, then you could vary those. I frankly took a look at that and couldn't figure out whether any of the provisions would not apply to this structure, but if somebody wanted to consider this a marquee, then you could grant a variance from whatever provisions you don't think are applicable here, and then it could be allowed as a marquee sign. And then finally, you could look at it as a porch, and if you accept what I had said earlier, that a porch is a structure that has a roof and then it goes over part of the building, then you could vary that, being called this structure a porch that goes over the sidewalk, and then you could allow the sign as a porch sign. I personally think the awning sign makes the most sense. Mr. Kerr believes the band sign makes the most sense. Either one of those, we would be happy with variances from either one of those. And in both cases, I think all of the standards that are listed in your ordinance are met. You know, this is a very reasonably sized informational sign that wouldn't hurt anybody. It's a sign that is similar to what almost everybody else in the district has. I think it's a unique enough structure that the ordinance simply didn't cover it, and that's why I believe your body was created in the Zoning Enabling Act to deal with this kind of situation. And I think Mr. Kerr would be harmed by not allowing him to have this type of sign. He could put up a much bigger projecting sign to get the property right of his name and company name out there to where people in cars could see it, but it simply goes against the conservative nature of his person and his business that has a reputation built over decades of hard work, and so we believe that this is a real textbook perfect case for granting a variance. So happy to answer any questions that you all might have.
Questions from the board? I have a question for Mr. Wood while we're doing this. It was suggested by the applicant that there's 4 different ways we could define what this structure is for the variance. Is that the thing we have to do in order to grant a variance?
Yes, what you'd have to do is to find that not only, first you'd have to find that the conditions that are set forth in 154-608 were each met. So for example, let's say you were inclined to grant a variance, you would want to state on the record exactly what you were finding. We find that each of these conditions has been met, for example, for the reasons stated by counsel on the record. You would want to be very specific as to what you were granting in terms of the signage that you were allowing. For example, there's been a couple different signs suggested by the applicant here. One is a sign that's on top of the roof, a band type sign that he had submitted a photo of. Another one is on the face of it, similar to what you would see on a marquee sign. So you'd want to be very specific as to, one, that he had met all the criteria, the reasons he had met the criteria, what you were permitting him to do, and if there were any conditions. The other extreme of that, of course, would be if you were to find that he didn't meet the criteria, then you would list what criteria he hadn't met. But you want to be very specific as to what you would be granting the variance for.
Okay. And if I could just clarify that for a minute, because I might have not been clear enough in when I went through the 4 different variances that are possible. If I can approach, and I know you had this up earlier.
Yeah. Mm-hmm.
We have it.
So that is...
That's on the face of the overhang.
So that is the sign that I have requested a variance for 4 different ways. In each of the 4 options that I presented, the sign would stay the same. It would be this, you know, not up higher, not at the top, not sticking out, not hanging underneath. It's that sign, and I think you could accomplish that 4 different ways. And some of them might seem silly. You know, maybe this doesn't look like a marquee to you, and so, yeah, you're right. But technically, you could vary the conditions of the marquee and call that a marquee if that's what you'd rather do. I think it's an awning, or it's moving the band sign from the facade out a little ways. Those to me are the 2 logical ones, but 4 different ways can get you that. So.
Okay. Currently, how does Mr. Kerr advertise on his building?
I think that's you, Dave.
I have a plaque right next to the door.
Right.
And that's why you can't see it from the parking lot. You can see it from everybody.
I have a question.
One of the reasons I want this, I was a little ill in 2015. Everybody thinks I died. I'd like them to know I'm still alive.
Right, yeah. And then another question, if the variance is denied, is the other option to tear down that structure? So you could put a sign on the facade itself?
Sure, I could tear the overhang off.
Right.
I think that would be an option. I think I'd probably go for the sign I don't like instead. In this body, they will kind of decide how the downtown goes. But that's been there for 50 years.
There's function to it as well. I mean, we had inclement weather lots of the year, and
We had a group of people from California help with the ordinance, and I don't know how snowy it gets in Los Angeles, but those overhangs and the awnings that we have cause us to be able to allow people to walk on the sidewalk before we get to shovel. There's a clear path, usually 18 inches or so. So I would be reluctant to tear that down just to get a sign because I think it serves other functions. Also, when you're getting your keys out and trying to get into the building when it's raining, you don't get dumped down there.
Right.
I think that's why we have a number of awnings and a number of things downtown where people have covered the sidewalks to make it possible to have pedestrians be able to use it.
You have a question?
I have a few questions. First of all, I'm glad you recovered. I'm glad you recovered and are still with us. But my question is, why wait from earlier until after the new zoning ordinance was passed, when the sign ordinance of the prior zoning ordinance would have allowed a sign of your choice?
I didn't pay attention.
Fair answer. My second question is somewhat for Mr. Kinch. What happened between March 7th and September? Like this original, it says here that there was no response given to in March when
I think the application was submitted and denied. He was asking for something in writing on the denial, so that's what we end up doing.
Okay, so there was just no delay, there's no real delay between
He
March
spoke with his contractor.
and September, okay. My last question is perhaps for Mr. Wood, I'm unsure, but it was mentioned several times by the applicant that our current zoning ordinance does not address this type of structure. My question is, would the ordinance be written to cover this type of structure if this particular type of structure is no longer allowed? So these permanent extensions from a building's facade that are now grandfathered nonconformities, if the intent of the community in adopting the new ordinance was to eliminate those structures as nonconformities were reduced. So is this an omission from the zoning ordinance, or is it the intent, because the intent of the ordinance is to reduce nonconformities over time?
Well, the intent of the ordinance, as you know, being a form-based ordinance, it's a new type of ordinance, and so the purpose and intent of the ordinance actually is to create zones and areas, walkability, et cetera. And that's why you have these definitions created that would apply throughout. And as the applicant's attorney indicated, you can't think of every single structure. You also combine that with the law that says nonconforming uses are not favored. So you wouldn't write into an ordinance that you would be adding a nonconformance that doesn't comply with the ordinance, even if you were under the old use type of use-based ordinance. This actually is a different type of ordinance altogether. But you wouldn't list, we're going to add these nonconformances. You would deal with them generically as a nonconforming use.
Other questions?
Yeah, I have, I guess through you one, and I apologize, Counselor, I should have asked you while you were up there while you had the right paperwork out. In terms of the 6 points, the first point, there's A, B, and C possibilities. I think we can eliminate A and C. Could you address more specifically for me any exceptional, topographic doesn't work, or extraordinary situation on the building or structure that would make this highly unusual?
Well, certainly. Now, I think what I said covers it. What you have is a large, larger than bay window by, your rendering, a large structure that is attached to the facade that is extended out over the public right-of-way, and that's an exceptional building or structure.
Okay. So,
you don't
so
see
this
it
would be an
very often.
extraordinary situation by the nature that this is not an awning under the ordinance. Is that a correct
That's
interpretation?
correct. There's a lot of awnings that were included in those photographs. Right. Most of them, well, they all had signs on them. I'm going to venture that most of them are non-conforming. But the types of structure that we have here, really, there's only 2 of them in the whole district.
Okay, thank you. And then I have 2 more questions, not of you, sir, but one of either Brian or City Council. We had in the write-up, am I getting this right, that we may not consider nonconforming signage displayed on other buildings as a basis? That's correct, right? So I have the record. That we cannot consider other nonconforming signage displayed on other businesses as a basis for our decision.
The property right on the adjoining property is the right to maintain nonconformities. If they take them down or want to alter the sign in any way, it has to be brought into compliance with current code.
I believe the applicant's counsel did actually state that correctly. He was not proposing it for that purpose. He was suggesting that because there are some non-conforming uses that it wouldn't affect those properties.
Yeah.
So I think he was using it in a different
Yeah,
context.
I understand that, and I wasn't playing off that. I was playing off a fundamental procedural thing. Secondly, Brian, if somebody either put up a new building or refabbed an existing building with this kind of structure that we've been dealing with all night, they would or would not be allowed under the new ordinance to put up this kind of bandstand?
They would not.
Okay.
That was what I was trying to get to with my question. Thank you, Commissioner Orlick, is that that kind of undefined structure is no longer allowed.
Okay.
I go back to each district, and in each district, they talk about frontage types, and they also talk about permitted encroachments. And in the CD5, they don't allow porch construction to extend over the property line. They limit that even as a frontage type in the CD5. But if you go through each district, there again, bay windows, signage, some of the signage is permitted as an encroachment as we go through here, like a blade sign or the large projecting sign. Those are permitted encroachments.
Okay. So putting this another way, in my simple mind here, if someone were to put up a new building or a refab of an existing shell, they would have 2 choices. 1, not put up this kind of a structure if they wanted a sign, or 2, put up this kind of structure realizing that under the ordinance they could not get a sign.
Yeah, they wouldn't even be able to put up this type of a sign.
Oh, really? Okay, yeah, okay, that's what I wanted to have clear.
They would be building at the frontage line,
Mm-hmm.
and then they would be following permitted projections, bay windows, those types of things, but this wood structure would not be able to be.
An awning would be, but a fixed closed position would not be. That was, I think, is important for us to have in the record.
Other questions for the applicant? Hearing none, thank you.
Thank you.
We will now open it for a public hearing on the applicant's proposal. Anybody wish to come forward and speak to this? If so, state your name and your address. Seeing none, the public hearing is closed. Now, Mr. Kinch, is there any correspondence?
We don't have anything on this case.
Okay. Here, no correspondence. Now we're open for the board to have discussion among ourselves. And when we do have a motion, if I understand right, we still have to state that in the affirmative?
That is correct.
And then go through the 6 standards. Okay. Any discussion?
Okay, to get us rolling, I would move that we approve a variance for this band sign.
For ZBA 04-2018. Okay.
I'll support.
Okay. Any discussion? We need to go through the 6 standards.
Maybe we can alternate these. Let me talk about one, which was the underlying reason for a couple of my questions. If we were in a situation, as in some other states, where we could consider non-conforming uses as something that can be measured against, then I would say that we would have an extraordinary situation in not allowing this sign. However, we can consider those, so I don't see any extraordinary situation in this building or structure that would allow us to give a variance to the ordinance.
Other discussion? I think I might disagree with that interpretation. And it probably, because I kind of combine it with some of the others, the age of the structure, the fact that it's been there for a long time, and that it's not their fault that the building was built that way from that perspective, and the need to advertise a business would be an extraordinary or exceptional circumstance, I think.
Yeah, I think certainly your point, Steve, in terms of is germane to number 6, not created by any action of the applicant or previous owner. I think certainly that relates to the artifact that we're dealing with here.
Yeah. I have a question that maybe Mr. Kinch or Mr. Kerr will know the answer to. Is this undefined red structure an original part of this building, or was it added at some point post-construction?
I would say this is added at some point.
So it is not a part of the original building?
That is correct.
I think it's over 50 years old, but I don't think it was part of the original structure. I think that came in when Consumers Power and Michigan Consolidated Gas Company and the telephone company were all next to each other. And I think that I remember them being there. And so I think they built that structure and it kind of combined the three together, the three utilities. Then later, they moved. But I've been here for 54 years and it's been here during that time.
So for number 2, I think the applicant probably meets that standard because it would be the enjoyment of their property. In looking at it, yeah, I don't think that it will affect others who might be coming forward. It doesn't set a precedence, and it's not a detriment to any of the adjacent property owners because they're all doing it. And as I said, it's not their fault. I mean, it's been there for 50 years, so.
Commissioner Orlick, you are stating that we cannot find that 1 subsection B is met.
I was raising the question. I'm not sure in my own mind if it's fully met or not, to be quite honest with you. Yeah.
I would just for discussion, just remind the board there are other sign types that are permitted at this property.
Yes.
Window signage, blade signage, the large projection signage, although they show a fairly large picture, they give us maximums, but they don't give us minimums. So if you look at that, it says maximum 50 square feet. So, you know, to downsize that, it still has to be placed certain places or certain locations on the building, but they still have the possibility for that sign type.
Can you talk a little bit about...
And that was also pointed out that we need to define what kind of sign, if we approve the variance, what that sign looks like.
Can you talk a little bit about the blade sign in terms of what would be allowed, where it would be allowed to be placed?
It's perpendicular to the building.
Like the one the bird has.
Yeah, and I understand the applicant's looking to place it parallel with the building for advertising across the street, and people out on the, actually using Main Street, so.
And it has to be perpendicular to the front facade. It cannot go on the corner.
Can't go in the corner, it would be over his property line.
Gotcha. Brian, I'm not sure that one would fit anyway because it needs a minimum height of 8 feet, and that awning might be low enough that it would be below that. But I do think a large projecting sign is in the ordinance, would meet the requirements of vehicle traffic being seen. So, I mean, might not be the kind he wants, but it does fit in the ordinance. So I think for number 2, there is he would still have that, enjoy the substantial property right.
That's
right,
why I
being
wanted to
able
mention
to
that.
advertise it.
Brian, could he put up an awning, as the ordinance defines awning, of the same size and with the same signage?
Yeah, if they took the wood structure down and put up a
Yes, that's my
cloth
question.
awning.
Yes.
The other piece of the awning was intended to allow the architectural features to still remain exposed. And so if you look down through here, it talks about does not conceal architectural features, has no side panels or soffits. So could it be reconstructed or removed and put an awning up? Yes.
And the awning could be essentially the same size, and the sign could be the same size, but it's now a sign embedded in the awning.
Right.
Yeah.
Signage would go on the valance essentially in the fascia location of this roof structure.
The way I read that, though, I think the awning would be less intrusive, or, you know, it wouldn't be as large. It wouldn't, it would be smaller.
But it wouldn't have to be, right?
Right.
And a window sign is
According
also
to what
allowed
that
there.
says, yeah. You couldn't put an awning up that's that big, right?
We have other signage in the downtown area that we're dealing with similar structures. So this is, we may see other requests to the board at some point, so.
The window signs would also have to be on the first story.
Right.
So I just wanted to remind you that if this is denied, there's still options in the ordinance for this site.
Can I make an amendment to the motion as the chair? You can. Just so it's defined in the motion, we need to determine that if we approve the variance, that the proposed sign does not extend higher than what the facing is of that structure.
That's fine.
Just to remind you, you have to meet all the requirements to grant the variance of the request.
Yeah, I would support the motion with that amendment. I would continue to support it.
I guess I'm saying, I think he meets all of those variance requirements, but.
Okay. We've gone through the 6, and I think we've articulated 2 through 6 are fine. Given the alternatives that are available, I just don't think 1 is met. That's my feeling, which is why I asked and drilled down on 1.
Right.
I can buy the other 5 as we've talked about them, but I think you have a really, if it was such that there was no way of getting clearly consumer identifiable signage on the building, then we're talking a real issue. But as we've just mentioned, there are several alternatives that could be done.
I sit in between the two of you, both literally and in making this decision. And I guess I also have the perspective of currently being chair of the Historic District Commission, which was a commission that was looking at signage in the downtown corridor specifically to preserve the historic nature and aesthetic of our downtown. And I hear the applicant saying there are few structures with this, there are few buildings with this undefined structure. You know, looking through here, I think it's what, like the Blue Gator has one, and then I'm not even sure which building this is. I know it, but
I think there's only 2.
yeah, I think it's 215 East Broadway and 205 East Broadway. So in that, to that end, this is an unobtrusive sign in fitting with the intent of preserving the character of downtown, and with a few of these undefined structures. I can agree with Chairman Berkshire that we meet the standards. On the other hand, there are other options, and I don't know, I'm sitting.
Yeah, the problem that I have, and I agree with you entirely, is that I had, personal opinion, I had wished that the ordinance had more tracked with the Historical Commission's objective. It didn't.
No.
And so we're stuck with the ordinance as it exists in front of us. And so I think that's where intent and my positive nature toward what you said is limited by the reality of what the ordinance is trying to do.
Mr. Chair, may I ask you to, there's a clarification that I'd like your attorney to address, if you would give me an opportunity to ask it of him.
Anybody objecting to having the applicant ask?
No.
Go ahead.
Mr. Orlick made a point about the 1B. He asked the question to me, and I wanted to address this then, but didn't want to feel like I was ducking his question. As Mr. Wood indicated in section 154.608B, it says in order to get a non-use or dimensional variance, the applicant must show that all of the following conditions exist. But when you get to subsection 1, the condition is exceptional or extraordinary circumstances. Then the last phrase in that paragraph says exceptional or extraordinary circumstances or conditions include, and then there's A, B, and C. So it's not limited to that, nor does it say that all three of those are needed. And in fact, in most of your variances, take, for example, you have a very narrow lot and you can't meet the side yard setbacks and have a structure big enough to meet your minimum house size. That would be the extraordinary circumstance, and yet you might not have exceptional topographic or other, B and C may not be met. So I don't believe that all three of those subsection 1 have to be met.
Nor do I.
Defer to your
I
counsel
don't
for
think
that.
so.
Thank you.
Yeah. I would agree that not all three of those have to be met. It doesn't say including but not limited to or by way of example. I think you have to meet at least one of those categories, but all the categories are fairly broad, so.
Other discussion on the board?
I'd just like to mention, Mr. Berkshire mentioned that. I think with referring to the question of number 1, I think with the, like you said, the age of that awning structure, whatever we call it may be, I just think when you look at the height and the angle that it goes from the top of the windows to almost the bottom of the windows on that second floor, whether that's, I don't know if that's owned by the same owner or how that works, but I think you could see where that could be a tough spot to put to where it just make it tough for the applicant to, I would agree with you in that aspect, so.
Other discussion?
Maybe just one more comment.
Okay.
Mr. Zimmerman pointed out that the new zoning ordinance can't cover every possibility, but I think one of the strengths of a form-based code is that we are trying to create a certain pedestrian-friendly look, and so I think we do have to weigh heavily on the appearance of what we might call an awning there too, where if the form-based code didn't specifically say that type of structure, and I have pause being able to grant a variance to put a sign on something that already wouldn't be allowed in the district.
I have trouble with that too. And since you're our liaison with the Planning Commission, right. Commissioner Friedrich.
I already have a question with them.
And going back to what Commissioner Orlick said about how the Historic District Commission had come so far in creating a signage ordinance that really kept into the character of our downtown and I think encapsulated the spirit of what our community is trying to achieve for our downtown. Is it possible for the Planning Commission to look at some of these discussions that we're having and say, let's think about this and maybe have a conversation with the Historic District Commission so that we can maybe better define, et cetera, because I'm stuck right now. I don't necessarily see how we can grant this variance. On the other hand, I am sorely afraid that if we do not, we're going to end up with Mr. Kerr putting a sign up that goes against what our community was trying to achieve. So I feel like we're in between a rock and a hard place.
I agree.
And I don't like it.
Just for the record here, on page 116, it does talk about in the CBD TIF, which is our downtown, that all applicants for new and change signs in the CBD TIF are encouraged to use the downtown Mount Pleasant signage design guidelines. And if you recall, the Historic District Commission was involved with that.
Yes, yes, we
so a lot of
worked on that for quite some time.
So a lot of the sign types that are in our ordinance directly relate to what we have in place under our new sign standards.
I know, but I know that because I was part of that conversation and that study and that work, we were trying to go away from awnings in the look and feel and bring back the original historic facades. Absolutely. And so to that end, we're basically saying this is an undefined awning type structure that's relatively solid and looks okay. Oh, let's tear that down and put up a painted metal thing. Like, I feel like that's a regression. And I don't necessarily know if that's what we want to be encouraging.
Yeah, there's no question this is this is a very tough call, and you can have good reasons for going either way, unlike some of the cases that we have. Ultimately, I think it depends on how you really see that this tracks with the ordinance, what the ordinance allows, and how we as a board and we as a community go forward from this particular case in terms of what might be precedent and what might not be precedent.
That's, in terms of, and I really shouldn't think out loud here, but I want my fellow commissioners to talk this through with me. In terms of subsection 1, which is, I think we're in agreement, this is where we're sticking. We've eliminated A and C as not relevant to this particular conversation. In terms of being an exceptional structure, I don't know. Mr. Wood, stop me if I go way out in the woods here. Can it be exceptional because this undefined structure is of historic nature? And
our earlier vote decided that this is part of the roof, by the way.
Yeah. Mm-hmm.
yeah.
Yeah.
And I would say based on our ordinance, the way they talk about and outline and define frontage types, that the ordinance actually address those types of structures by excluding them.
Yeah, looking at this another way, and this is the reason I'm coming down as I am, the extraordinary situation of the building or structure. I would buy that if the extraordinary nature was allowed under the ordinance, but it's not. And consequently, I don't see it as an extraordinary, I see it as a non-conforming thing that we're not supposed to protect. That to me is the rationale for it, yeah.
I understand.
That's true, yep.
I mean,
It's supposed to reduce the nonconformity. Other discussion? Are you ready for a vote?
Just remind everybody we have to, the motion was made in a positive way because that's our rules.
Mm-hmm. Right. Can you repeat the vote or the motion, Becky? Becky, you can't.
Okay. With the amendment, yeah. I will do my part and then Steve can articulate his amendment that I agreed to. I simply moved that we grant a variance for the requested sign requested under under ZBA 04-2018. And then, Steve, whatever you added
With
to
the
that.
limitation of the sign size, so it doesn't extend above the face.
I'm sorry to interject again, but I believe the original motion was that it was a banned sign.
Okay. Thank you.
Right, yep. Yeah,
Yep.
my amendment was to limit the size of that band sign.
Mm-hmm.
Right. Okay.
And forgive me if I'm confused, but I just want to make sure your record is clear that when you say a band sign, that you have either a picture of it for the record or a diagram or something so that there's clarity that either it's on the front, as the one photo shows, and not on it. Yeah.
That's the one.
That the
we're
band
talking
sign as submitted in the applicant's request. Add that, we're fine, sure.
about. Okay.
Roll call?
Do you want a roll call or just?
I think it's a good idea.
Pardon?
I think a roll call would be a good idea since we have a lot of discussion on this.
White?
What do I, just vote as I, so we got to vote in the positive?
You have to vote in the positive.
Or
No,
the
the
motion
motion's in the
The
positive.
motion's in the
motions in
positive.
the positive, you can vote yes
If you vote yes, you're approving the motion, which is to grant the variance.
or no that you're not.
Yes.
Friedrich? No. Orlick?
No?
Raisinin?
One can abstain as well, correct?
Yes.
Need 4 positive votes.
I am sorry, but I abstain.
Berkshire?
Yes,
2-2. Motion fails.
the motion failed,
It's denied.
denied, yep.
We would have needed 4 positive.
4.
Yep. If you voted yes, it would have failed.
Right.
Right, okay.
But I couldn't make a decision. This was very difficult for me.
On the agenda is old business. Mr. Kench, is there anything
I
to?
don't have anything to report under old business.
Okay. I asked him earlier, just to make it public, our vote last time where we denied the appeal. Mr. Kench told me that the sorority is tearing out the patio.
I saw that, yeah.
Our next item is the proposed agenda for 19. I think Becky included that in your packet.
Yep. The meeting dates for 19, we need an approval of those.
I'd like to state, I guess now, that it is quite likely that I will be away on both June 26th and July 24th, 2019. At this time, I don't have conflicts with the other proposed scheduled dates, but
Well, our meetings have been fairly rare, so maybe we'll get a pass in June and July of 2019.
that would be good.
And the last item under November ZBA meeting,
Do we need to approve these, Brian, or is just for?
Yeah,
we can approve them now or we can approve them the first of the year, but
Well, I think let's
Might
get
as
them
well do it
down
now.
so we can all mark things.
Do it now.
I would move approval of the next year's meeting schedule as submitted.
Second.
all in favor?
Aye.
Aye.
Any opposed? Hearing none, okay.
Under go ahead with B, sorry.
I was just going to say, under the November ZBA, at this point, we still have some time for applications to come in, but we haven't talked with anybody. We're not anticipating anything, so.
Okay.
Oh, I'd like to ask if it's even possible. This was, I think, something where under the form-based code, we're seeing some potential conflicts with the intent of people who worked really hard on creating aesthetic and sign guidelines for downtown and what the code will allow. I'd just like to ask Commissioner Friedrich to take this back to the Planning Commission.
Of course.
To talk about this case a little bit and just see, are there any clarifications that need to be made? Are there any adjustments, et cetera? I'd just like to request that, please.
Of course.
I think the Planning Commission, first part of the year, have committed to, after we've gone through it a year, working with the city planner, identifying things that may need to be changed, things that need a little bit more definition, that type of thing, and this surely can be one of those.
Good. Anything else? Motion for adjournment?
Move to adjourn.
Second?
All in favor?
Aye.
Aye.